So I'm going to really go back to basics and go back to what the directive considers to be a proxy advisor and look at why it's important to regulate them.
So which member state
who is
regulates
responsible
which
for regulating them, and exactly
The
which
report
proxy
from ESMA's
advisors are regulated by the EU requirements, and then look at what the requirements are. And then recently there has been a review of regulation of proxy advisors, and ESMA has made some recommendations. And as Ralph Zoyer was saying yesterday, we're waiting for the Commission report as to what it is they're going to recommend should be changes in this area. So it's a very topical area. So if I start off with what is a proxy advisor, there is a definition in the Shareholder Rights Directive, and it defines it as any legal person that analyses corporate disclosure and other listed company information. So that would include the company's report and accounts and any other public announcements it makes onto a regulated market, for example, because they're doing an acquisition or they're disposing of a major asset, or it might be a change in the directors of the company. So any analysis of that sort of information. The analysis has to be done on a professional and commercial basis. So if you're an individual doing it for your own purposes, you wouldn't be caught by the definition. And you have to be doing the analysis with a view to informing the voting decisions that are made by investors. And the way that you would be doing that is either by providing research to them or giving them advice or making a recommendation to them as to how they should vote in relation to the shares that they hold in listed companies. And that definition is set out in Article 2G of SRD. I thought it might be helpful to give you a diagram. I always find diagrams helpful, just to show where proxy advisors fit into the system and why I think they're so important. So if you start on the bottom right-hand side of the diagram, you can see there's the listed company. And very often the shareholders of a listed company are not actually the people who provide the money to invest, but they're a custodian bank. So they're an organisation like Northern Trust, for example, and they're really an administrator. So they're responsible for keeping the records of the shares, and when somebody buys or sells the shares, they make the arrangements to transfer those shares. The person whose money is really being invested, which is the investor, might be somebody like a pension fund, or it could be some sort of collective investment vehicle. And they are the people who care about whether the money that's being invested into the listed company is going to grow over time or not. But quite often these days, because these are very large organizations, they subcontract responsibility for taking decisions about which companies to invest in to fund managers, also known as asset managers. In fact, the Shareholder Rights Directive refers to them as asset managers. And so the institutional investor enters into a contract with the asset manager for them to provide those services to them. It's the fund manager that makes the decision about which companies to invest in, when to sell those shares, when to buy shares in other companies. So you might think, well, as far as the company is concerned, then it's the fund manager, the asset manager, that the company needs to talk to, because they're the people who are deciding whether to buy or sell the shares. And if the company wants to raise more money, that's the person you would have to convince, because they're the ones who are going to decide whether to put more money into your company or not. In practice, what's happened over the last 20 years or so is that proxy advisors have come into the picture as well. And what the proxy advisors do is they do what it says in the definition in the directive. They are reading all the information that the company's put out, the report and accounts, the other announcements that the company makes. And then they provide services to the fund managers and make recommendations to them as to how they should vote on resolutions and what actions they should take. So they are very important people. And it's obviously more efficient because the proxy advisor reads the report and account and other information from the company once, but they may have a large number of asset managers who are their clients, and they're giving their recommendations to all their clients. So the picture has become quite complicated, but you can see, because they're the ones making the recommendations, they have a lot of influence. Part of the problem that the listed companies may have is that it may not always be easy for them to identify which proxy advisors are being used by which fund managers. And therefore, as part of the corporate governance dialogue that we want to happen between listed companies and their shareholders, the more transparency we can have about what people are doing and how that all works, that's really important. So why did the EU think it was important to regulate proxy advisors? Well, after the financial crisis, people were very concerned that the shareholders, by which they meant the institutional investors, had supported too much risk-taking by some of the listed companies, in particular in the financial services area, the banks and so forth. And the Commission was very keen to encourage more engagement between shareholders and listed companies, and for them to concentrate on what were the long-term prospects of the company, not just the short term. And also they wanted to enhance transparency, because without transparency, you can't make this work properly. And so when changes were made to the Shareholder Rights Directive in 2017, and I put the directive number on the slide, what the directive did was to put obligations onto institutional investors and asset managers. But because the asset managers were making use of proxy advisors and their services, it was also thought to be important to place regulations on the proxy advisors too, and that they should be subject to transparency requirements. Just briefly, so you know, what the directive does is to say that institutional investors and asset managers have to explain what their approach is to engagement, and think about how that approach is consistent with the long-term obligations that they have. So if you're a pension fund, you obviously have long-term obligations to pay pensions to the people who benefit from your pension fund. If you're an asset manager, then the obligation is to provide information to the institutional investors that you have contracts with, so that the institutional investors can tell whether the strategy that you're taking as their asset manager is allowing efficient and good shareholder engagement with the listed companies. So which member state regulates which proxy advisors? This is a bit complicated. So the directive tells you three things. Firstly, it tells you that if a proxy advisor has a registered office in a member state, then that member state will regulate it. But it may be the case that the proxy advisor doesn't have a registered office in a member state. And so in that case, you look to see where does the proxy advisor have its head office, and it's that member state which will then regulate. But you could have situations where the proxy advisor doesn't have either its registered office or its head office in the EU, and then it'll be the member state where it has an establishment. The directive also tells you which proxy advisors are regulated, and it's proxy advisors to the extent that they provide services to shareholders with respect to the shares of EU companies that are traded on a regulated market which is situated in a member state or operates in a member state. So if you're a proxy advisor and you're providing services in relation, for example, to Porsche, whose shares are traded on regulated markets in the EU, then you would be caught. And it doesn't matter if you don't have your registered office or head office in the EU, as long as you have and establishment in the EU. And I did a bit of checking this morning. The two big proxy advisors are ISS and Glass Lewis. And ISS, for the governance part of ISS, has offices in Berlin, Brussels, and Stockholm. And Glass Lewis has offices in Ireland and Germany. I certainly know that Glass Lewis is headquartered in the US, and I think that's true for ISS governance, but actually looking at the website, it's really difficult to get the information for sure. ISS, you might be interested to know, is majority owned by the Deutsche Börse Group. So what is it that the directive says that the proxy advisors have to do? What the directive says is that you have to publicly disclose a code of conduct that you apply, or if you don't apply a code of conduct, then you have to give a clear reasoned explanation of why you're not applying a code. So yesterday we were talking about the OECD Principles of Corporate Governance and the comply or explain approach, and the Commission adopted a similar comply or explain approach for the proxy advisors. And if you do apply a code, then you have to report on how you apply it, and in particular, if there are bits of the code that you don't follow, you have to make clear which are the bits that you don't follow and why you don't follow them. And if you do something different instead, you have to explain what it is that you do instead. And most of the proxy advisors, certainly ISS and Glass Lewis, follow the best practice principles for shareholder voting. And they have a website if you're interested in finding out more about that. The information that you provide has to be publicly available, free of charge on your website so that it's easy to find, and you have to update it annually. The directive actually goes into quite a lot of detail about exactly what sort of information you have to provide about the way that you prepare your research, the way you give advice, and the voting recommendations that you make. So, for example, you have to say every year what are the essential features of the methodologies and methods that you use in order to do this, and what are your main sources of information. What procedures do you have in place to make sure that you've got good quality research advice and voting recommendations? And what are the qualifications of the staff that you use to do this sort of work? Do you take account of differences in national markets and differences in the legal and regulatory approach and conditions that are specific to particular listed companies? And if you do, how do you do that? And you have to give information about what the essential features are of your voting policies for each market that you're operating in, and talk about how you have dialogue not only with the listed companies, but also with the stakeholders of the listed companies. Do you have to say, do you do that? And if you do, then you have to give some more information about how you do that and the extent of what you do. And you also have to give information about the policies that you have either for preventing conflicts of interest arising in the first place, or as it's quite difficult to stop conflicts arising completely, how you manage conflicts of interest when they do happen. And all of this information has to be available for free for at least 3 years on your website. Because there was a worry about the area of conflicts of interest, there are further provisions on those. So what the directive says is that you have to identify not only actual conflicts of interest, but also potential conflicts of interest, and you have to disclose those to your clients without delay. And also if you have any sort of business relationship that might influence the way in which you prepare your research or the advice or recommendations that you give, you also have to disclose those. And also you have to say what actions you're taking, either to stop the conflicts arising in the first place or to manage or mitigate the conflicts when they do arise. So quite strict provisions on conflicts of interest. The directive actually said it's got a provision in it that said that there had to be a review of the provisions relating to proxy advisors and their regulations. And in fact, that was due to happen by, I think, summer of last year. But for various reasons, I think it took longer for the European Securities and Markets Authority to do a report for the Commission. That came out in July last year. And the European Banking Association also provided input to that. And then, as we were told yesterday, there's going to be a report to the European Parliament and to the Council on this. The report from ESMA starts off by saying that the services that proxy advisors provide are very much valued by both investors and asset managers. But it's still the responsibility of either the asset manager or, in some cases, it's the institutional investor who decides how it is they're going to vote on the resolutions put forward by the listed company. In 2013, when ESMA did a review as to how the provisions were working, what they said was, we can't find any evidence that there is a market failure here. And they thought that overall, the way in which the regulatory framework was working was gradually improving. And so in 2013, ESMA thought that the approach that we had in place was good enough and should be kept in place. The report says that ISS and Glass Lewis between them have a combined global market share of over 90%, which is pretty large. Glass Lewis bought iVox, which is a German-based proxy advisor, in 2015, and a French one, Proxinvest, in 2022. There are some other proxy advisors that you might have come across. So there's EOS at Federated Hermes, which is a UK proxy advisor, PIRC, or PERC, which is also a UK one, and Minerva Analytics, also UK. And there are also a few proxy advisors headquartered in EU countries, which have a focus on their domestic market as well. But you can see from the statistics that the share that they have of the market is quite small, and it's really ISS and Glass Lewis, which are the important players here. After ESMA did its review in 2013, there was a group established called the Best Practice Principles Group. And what they did was to put together best practice principles for proxy advisors. And this is a code of conduct that proxy advisors can sign up to and say that they will follow and use, and then disclose against. And that was last reviewed in 2019. And it takes an apply and explain approach. So there are 3 principles, one to do with service quality, one to do with conflicts of interest avoidance and management, and a third one to do with communications. And if you go onto the website, I think they have a list of signatories. In addition to that, more recently, the Best Practice Principles Group has established an independent oversight committee. And the idea of that committee is that it will look at the sorts of disclosures that proxy advisors are making and will try and improve practice in this area. You might also know that some proxy advisors are signatories to stewardship codes. So the UK, for example, has a stewardship code, and that has provisions in it, and proxy advisors can sign up to the provisions in the stewardship code. I think Japan also has a stewardship code that allows proxy advisors to sign up to it, and this is all on a comply or explain basis. So a lot of self-regulation in this area. So what was it that ESMA has said to the Commission? The first thing is that they think it might be a good idea to look again at the definition of proxy advisor. The definition works well insofar as most people think it's catching the big relevant players in this area. But I think around the edges there's some uncertainty as to whether certain sorts of people get caught by these regulations or not. So in particular, they said, if you are not established as a legal person who's providing advice on a commercial basis, but you are a professional, it would be good to clarify whether you're caught by the definition or not. And similarly, if you're a non-profit organisation, but you're providing advice on a professional and commercial basis, it should be clear whether you're caught by this or not. Since the directive first started to apply to proxy advisors, we've obviously had the rise of interest in ESG data services and a real mushrooming of consultants who will give you advice in that area. And I think one of the problems is it's not always clear whether somebody who provides that sort of ESG data service advice or advice on governance or analysis and rating services in relation to ESG, whether they're caught insofar as it also includes advice on the exercise of voting rights. And ESMA certainly thinks that would be helpful. And they thought that it would be helpful if there could be an EU-wide registration mechanism. So if you are a proxy advisor who's caught by the regulations, you would have to register, and that would make it easier for people to find out who's regulated and who isn't. But ESMA also said you need to be careful because the EU is considering a regulatory framework for ESG rating activities. So you have to think about how those two areas fit together. At the moment, there are no requirements in the directive as to what a code of conduct has to have in it. And so one of the points that ESMA has raised is whether there should be something more specific about what features a code of conduct should have. And in particular, whether there should be a requirement for some sort of independent monitoring mechanism. One of the problem areas is that not all proxy advisors provide good explanations when they're not following a code requirement. ESMA certainly thought that the fact that the BPP group had introduced an independent oversight committee had been very helpful. And they think that the annual review that independent oversight committee is going to do is likely to mean that there will be improvements in disclosure in the future. But some of the issuers and also some of the local proxy advisors suggested that you should go further. For example, they thought it would actually be helpful to have a European code of conduct that proxy advisors could use. And some of the local listed issuers wanted there to be a national competent authority which would have to monitor what the proxy advisors were doing and, for example, make an annual report and report to ESMA about it, which would allow more scrutiny of what practice in the market is doing. They thought that that would provide further clarity to the public more generally. The next area is to do with disclosures. ESMA said that overall there's a positive picture of market practice, but where there is a national competent authority which is interested in what proxy advisors are doing, sometimes they found it hard to come to a conclusion based on the information that the proxy advisors are publishing. And the area of dialogue between proxy advisors and issuers is the area, I think, which causes most problems. If you're a listed company and you've put out your notice of annual general meeting and it has a lot of resolutions in it, what you really care about is that your shareholders are going to vote in favour of the resolutions that the directors have recommended. And the issuers want to see the report that the proxy advisor is going to write to its clients about its notice of annual general meeting In particular, what issuers care about is where there are mistakes in that. And they want to be able to have the opportunity to correct those mistakes. And if they think that there's a relevant bit of information that hasn't been included in the proxy advisor report, that they should have an opportunity to comment on that. What they say is that even in circumstances where proxy advisors are willing to do this, often the time that the company gets to check the report and to give comments back is too short. And sometimes even when they do give comments, the proxy advisor ignores their comments. I should say, to be fair, that some of the proxy advisors say that the comments that they get from the companies are not always of a good quality. And so the conclusion that ESMA has come to is that it might be helpful if there could be a framework for a more structured dialogue between the proxy advisors and the listed companies. Part of the problem is that in some markets, the cut-off date for shareholders to vote is maybe as much as 15 days before the date of the general meeting, if you're voting in advance or giving instructions as to how to vote. And that can mean that there's a very short time period for proxy advisors and companies to have this dialogue about the recommendations that the proxy advisors are making. And very often, it can be in relation to remuneration for the directors. And you can easily see that that's a very sensitive topic for the company, because they're making recommendations as to what the structure of the remuneration should be for their chief executive, chief financial officer, and so forth. What ESMA suggests is that maybe ESMA could have a role in facilitating dialogue between the issuer and either the proxy advisor or the investor, whichever is appropriate for the particular situation, but that any recommendations that ESMA would make wouldn't be binding, and it would still be open, they say, to parties to seek judicial remedies if they wanted to. Personally, I don't know how that would work, and I don't know whether it would be possible to get a judicial remedy, certainly in the short time periods that we have at the moment, but maybe having a third party involved, particularly in these cases where there's a disagreement between the company and the proxy advisor as to whether something that the proxy advisor wants to recommend is fair or not. That might help. The other thing is that they suggest that the Commission could require there to be more specific disclosure of the information sources that the proxy advisors are using, particularly when it comes to ESG data. That seems to be, presumably because it's a hot topic, quite a sensitive area. And then the last area where ESMA is making recommendations relates to conflicts. Conflicts of interest. Sorry, no, this isn't the last but one. So on conflicts of interest, what they said was if there were more detailed disclosure obligations on the proxy advisor, would that help investors? And one of the things they have suggested, which is very practical, is that maybe you should have to put onto the front page of your voting recommendation the information relating to conflicts. Maybe the worry is that the information about the conflicts is getting lost somewhere at the end of the information. Conflicts is an area where generally it's considered to be less satisfactory. Proxy advisors are doing a less good job. So, for example, you may have a proxy advisor which not only is making recommendations on a company's proposed resolutions to asset managers, but also is providing services to the company as a consultant. For example, it might be in relation to remuneration or ESG. And so you can see that there's a potential conflict of interest. In particular, there's a concern that companies might feel that they have to use the services of a proxy advisor in order to avoid a bad report from the proxy advisor. And you can see that that's giving the proxy advisor a large amount of influence that maybe isn't appropriate. More detailed disclosure might be disclosure of things like when you're providing consultancy services to an issuer that you're then providing voting recommendations on. but also things like, have you got staff members who have previously worked for one of the companies, or staff members who have previously had some other sort of relationship with one of the listed companies. They do say that you would need to take account of confidentiality obligations when working out what these disclosures should be. They also have suggested that you should think about improving the list of public disclosures, and that maybe there should be a mandatory requirement to disclose the sorts of revenues that are generated by providing services to different types of clients and what the relative weight of those are. So that would be quite a major change, I think. And then finally, this question of proxy advisors who are operating not with a registered office or a head office in a member state, but who've got an establishment in a member state. And again, what Esma is suggesting here is that there should be a requirement to register on an EU-wide register. And that would then publish a list of the proxy advisors, and you would be able to see easily whether or not they are following a particular code. And it would be helpful to actually provide a link to the annual report that they put out, so that it would make it much easier for companies and other shareholders and investors who want to find out information about what the approach of a proxy advisor is. And Esma say that they think that that would provide better visibility and comparability. So we have to wait and see what it is the Commission is going to suggest. Certainly, I think from my experience of talking to people who work in listed companies, that they do worry about the influence that proxy advisors have. And I think the more that we can do to create transparency about that, the more likely it is that we will help that. And it is important for good corporate governance of listed companies that we do have a good, effective system. And if there are conflicts of interest in that system, that people are aware of those, and that proxy advisors know that because they'll have to disclose that to their clients, and it'll be visible to the companies as well, that they will come under scrutiny for what they're doing. So I'll stop there, and if there are any questions or comments, or if you know how proxy advisors work in the member state that you come from, I'd be very interested to hear.